Pennsylvania has a moderately regulated tenant screening environment where the state-level requirements are relatively limited, but several major cities, particularly Philadelphia, have enacted local ordinances that significantly restrict the screening process. If you're screening tenants in Pennsylvania, what rules apply depends heavily on where your property is located. Let's start with application fees. Pennsylvania does not have a statewide cap on application fees. There is no state statute limiting what a landlord can charge for tenant screening. The Pennsylvania Landlord and Tenant Act of 1951, found in Title 68, does not address application fee amounts or procedures. Landlords can charge whatever they determine is reasonable. However, Philadelphia has enacted its own provision. Under Philadelphia's Fair Practices Ordinance and related tenant protection measures, landlords in Philadelphia face restrictions that don't apply elsewhere in the state. Philadelphia has been at the forefront of tenant protection legislation in Pennsylvania, and application fee practices in the city are subject to greater scrutiny than in the rest of the state. Landlords in Philadelphia should verify the current local requirements regarding fee amounts and disclosures. Pittsburgh has also been active in discussing additional tenant protections. Landlords in Pittsburgh should monitor local ordinances and policy proposals that may affect screening practices. For landlords outside of Philadelphia and Pittsburgh, the practical standard is to charge fees proportionate to the actual cost of screening, typically $25 to $50 per applicant. Criminal history screening is where Pennsylvania's regulatory landscape becomes complex, because Philadelphia has enacted one of the most restrictive criminal history screening laws in the country. At the state level, Pennsylvania does not have a comprehensive ban-the-box housing law. There are no statewide restrictions preventing landlords from asking about criminal history on the initial application. Landlords outside Philadelphia can inquire about arrests and convictions, can use criminal history in screening decisions, and are not subject to state-mandated individualized assessment requirements or look-back period limits. Philadelphia is a completely different story. The Philadelphia Fair Criminal Record Screening Standards, enacted under the city's Fair Practices Ordinance, impose detailed restrictions on how landlords can use criminal history in screening. Under Philadelphia's law, landlords cannot inquire about criminal history until after the applicant has been provided with the screening criteria, and the landlord has reviewed the application based on all other factors: income, credit, rental history, and references. Criminal history can only be evaluated after the initial review of non-criminal criteria. Philadelphia landlords cannot consider arrest records that did not result in a conviction. Landlords cannot consider convictions that have been expunged, pardoned, or overturned. And Philadelphia imposes specific look-back period limits. Landlords generally cannot consider convictions older than 7 years, with limited exceptions for certain serious offenses. When a Philadelphia landlord does consider criminal history, an individualized assessment is required. The landlord must evaluate the nature and severity of the offense, the time elapsed since the conviction, the applicant's age at the time of the offense, evidence of rehabilitation, and the relationship between the criminal conduct and the tenancy. The landlord must provide the applicant with an opportunity to present mitigating information before making a final decision. If the landlord denies the application based on criminal history, the landlord must provide written notice identifying the specific conviction that formed the basis for the denial and explaining how the individualized assessment factors were applied. Philadelphia's penalties for non-compliance include damages, fines, and attorney's fees, and the Philadelphia Commission on Human Relations actively investigates complaints. Outside Philadelphia, the landscape is far more permissive, but HUD's 2016 guidance on criminal history and disparate impact applies statewide. Pennsylvania landlords in all jurisdictions should avoid blanket rejection policies and should document their criminal history evaluation criteria. Pennsylvania also enacted a Clean Slate Law, Act 56 of 2018, which provides for automatic sealing of certain criminal records after specified periods. Under this law, certain misdemeanor convictions are automatically sealed after 10 years if the individual has remained conviction-free during that period. Certain non-conviction records, including charges that were dismissed or resulted in acquittal, are also subject to automatic sealing. Once a record is sealed under the clean slate law, it should not appear on a criminal background check, and landlords cannot consider sealed records in screening decisions. The clean slate law is significant because it operates automatically. Individuals don't need to petition the court for sealing. This means that criminal records are being sealed on an ongoing basis as individuals become eligible. Screening providers should be filtering sealed records from their reports, but landlords should verify that their provider is current with Pennsylvania's sealing provisions. Source of income protection in Pennsylvania varies by jurisdiction. Pennsylvania does not have a statewide source of income protection law. Landlords outside of protected jurisdictions can consider the source of an applicant's income and can decline voucher holders. However, Philadelphia prohibits discrimination based on source of income. Under the Philadelphia Fair Practices Ordinance, landlords cannot reject applicants because they pay with housing choice vouchers, Social Security, disability payments, or other lawful sources of income. The Philadelphia Commission on Human Relations enforces this protection, and violations can result in damages, fines, and injunctive relief. Pittsburgh has also enacted source of income protections. Landlords in Pittsburgh cannot discriminate against applicants based on their use of housing vouchers or other lawful income sources. Outside Philadelphia and Pittsburgh, source of income protection does not currently exist, though additional Pennsylvania cities may enact protections over time. Landlords should monitor local developments in their specific jurisdiction. For credit reports, Pennsylvania follows standard FCRA requirements, permissible purpose, written consent, and adverse action notice procedures. Pennsylvania does not impose significant additional state-level requirements beyond FCRA for credit report access or adverse action procedures. Pennsylvania's fair housing protections under the Pennsylvania Human Relations Act, found in Title 43, Section 951 and following, prohibit discrimination based on race, color, religion, national origin, sex, disability, familial status, ancestry, age, and use of a guide or support animal. The inclusion of ancestry and age goes beyond the federal baseline. The Pennsylvania Human Relations Commission investigates fair housing complaints. Philadelphia's Fair Practices Ordinance adds substantially more protected categories, including sexual orientation, gender identity, marital status, domestic or sexual violence victim status, and source of income. Philadelphia's protections are among the broadest of any city in the country and create a significantly more restrictive screening environment than the state law alone. From a practical standpoint, Pennsylvania has a large and diverse rental market with dramatic variation between its major metros and the rest of the state. Philadelphia is the state's largest rental market and the sixth largest city in the country. The market is driven by health care, including the University of Pennsylvania Health System, Jefferson Health, and Temple University Health System. Higher education, Penn, Drexel, Temple, Thomas Jefferson, and numerous other institutions. Government, financial services, and a growing technology sector. Philadelphia has a diverse tenant population that ranges from affluent professionals in Center City, University City, and the mainline suburbs to lower-income residents in North Philadelphia, West Philadelphia, and other neighborhoods where housing assistance is prevalent. Philadelphia's comprehensive screening restrictions, criminal history limitations, source of income protection, and broad fair housing categories make it the most restrictive screening environment in Pennsylvania. Landlords in Philadelphia must treat the city's requirements as their compliance baseline. Compliance with state law alone is insufficient. Pittsburgh has a strong rental market driven by health care. UPMC is one of the largest employers in the state. Technology, including Carnegie Mellon University's influence on the city's growing tech sector. Higher education, CMU, University of Pittsburgh, Duquesne, and financial services. Pittsburgh's rental market has tightened considerably as the city has experienced a renaissance, attracting young professionals and corporate investment. Pittsburgh's source of income protections and active tenant advocacy community create a moderately restrictive screening environment, more regulated than the state baseline but less complex than Philadelphia. The Philadelphia suburbs, including Montgomery County, Delaware County, Chester County, and Bucks County, have strong rental markets driven by proximity to Philadelphia, corporate offices along the Route 202 corridor, and excellent school systems. These suburban communities generally operate under state law rather than Philadelphia's local ordinances, but landlords should verify whether any specific municipality has enacted local protections. State College, home to Penn State, has a massive student rental market driven by one of the largest university enrollments in the country. Screening high volumes of student applicants with limited credit and rental history is a core competency for State College landlords. A consistent cosigner or guarantor policy is essential. Allentown, Bethlehem, and the Lehigh Valley have growing markets driven by logistics, manufacturing, and proximity to both Philadelphia and New York. Reading, Scranton, Wilkes-Barre, Erie, and Lancaster have more moderate markets with varying demand levels. The military presence in Pennsylvania is relatively limited but includes several installations. Carlisle Barracks, home to the Army War College, generates some rental demand. The former military installations in the Philadelphia area have been redeveloped but don't generate significant military rental demand. Landlords near any active installation should understand military income documentation procedures. One best practice for Pennsylvania landlords: determine immediately whether your property is in Philadelphia, Pittsburgh, or another municipality with local screening restrictions, and build your screening process around the most restrictive rules that apply to your specific location. If you own properties in both Philadelphia and a suburban county, you need separate screening procedures. The rules are fundamentally different. Another best practice: verify that your screening provider is current with Pennsylvania's clean slate law. Records that have been automatically sealed should not appear on background reports. If your provider is returning sealed records, you're receiving information you're not supposed to have, and acting on it could create liability. Ask your provider specifically whether they filter sealed records under Pennsylvania's clean slate provisions. A third best practice: for Philadelphia landlords, build the two-stage criminal history screening process into your standard workflow. Evaluate all non-criminal criteria first, then access criminal history only after the initial review. Document your individualized assessment for every applicant whose criminal history you consider. Keep records of the assessment factors, the applicant's response, and your final decision. This documentation is your primary defense if the Philadelphia Commission on Human Relations investigates a complaint. Pennsylvania requires landlords to return the security deposit within 30 days of the tenant vacating. The deposit is limited to 2 months' rent for the first year of the tenancy and 1 month's rent after the first year. The deposit must be held in an escrow account at a federally or state-regulated institution, and the landlord must provide the tenant with the account information. These deposit limitations make thorough screening critical. Your financial protection against problem tenants is capped by statute. For the complete guide to Pennsylvania tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.